Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Behind the Binder with Brian Chu, managing partner at OC Wills and Trust. For over 25 years, Brian has helped families across Orange County protect their homes, savings, and legacies with thoughtful estate planning. I'm Chelsea, and today we're talking about retirement accounts like IRAs and 401ks and why they need special attention in your estate plan. With new rules around inherited retirement accounts, families can face big tax surprises if they don't plan ahead. Brian's here to explain what's changed and how to make sure these accounts pass smoothly to your loved ones. Welcome back, Brian.
Well, thank you, Chelsea, and happy holidays.
Happy holidays. Why do retirement accounts like IRAs and 401ks need this special attention in an estate plan?
Well, the biggest issue obviously with traditional IRAs and 401ks is the fact that, well, you haven't paid taxes on it yet. And the government at some point is going to want their money. Unlike, life insurance, checking, savings, regular investment accounts, when somebody inherits those assets, there's really little or no tax to be paid as a result of inheriting that money. However, with 401ks and IRAs, depending on what you do and how things are set up, it will definitely impact when your family, your heirs will have to pay taxes on that money. And ideally, you would like that to be as long as possible. You don't want to you want to defer, like you're deferring taxes now on your 401k. You want to continue to defer that for as long as they can based on what the law allows. And as a result, you mentioned the Secure Act, that completely changed when they enacted this law a few years back, changed the options families have as far as what's called rolling over 401ks and IRAs into your own IRA and how long you can continue to take tax deferral. In other words, defer the taxes on the gains made from the defer taking the money out of the 401k or IRA, because at that point, that's when you would have to pay taxes on all the money that comes out of an IRA.
What exactly did the Secure Act change about how families inherit these retirement accounts?
It used to be, this whole thing where, in theory, you could pass IRAs and 401ks on to family members, and depending on when they took the money out, they might be able to pass it on to the next generation. Okay, and people, you continue to grow money tax-free or tax-deferred, not necessarily tax-free, tax-deferred for multiple generations potentially. Well, the government didn't really like that because, well, they're not getting any money until you actually take the money out of the 401k and IRAs. And so they changed the rules slightly. The biggest changes is they did up the range for how long you can defer taxes. Before you have to take what's called RMDs, or required minimum distributions, it went from 70.5 to 72. So you can delay it. You, as the owner of the IRA or 401k, you can delay, instead of taking required minimum distributions, which is typically about 3 to 4% of the amount of money that's in, or the assets that are in a 401k or IRA, at 70.5, now it's 72. Okay, so you could take money starting at 59.5. You could take money out and pay no penalty. But any money you take out, you'll pay taxes. But at 72 now, instead of 70.5, you have to start taking 3 to 4% out every year. Otherwise, you'll pay significant penalties if you fail to start taking the money out at 70.5. Now, that's a relatively minor change. To the bigger change was how the money now goes to either your spouse and or typically your kids. The spousal part didn't really change too much. It's if the spouse, if something happens to the spouse, your spouse, and you inherit the money as a surviving spouse, you can now roll over the money into your own spousal IRA, and again, you'll be subject to the same age RMD at 72. You can take out money anytime you want. Actually, in this case, there's no age restriction as far as when you can take the money out, but you do have to start taking money out at the same age of 72, just like your spouse did.
So you wouldn't have to wait till 59 to start, but you
Correct.
Definitely have to start by 72.5. Okay.
Correct. Or 72, yes.
72.
Now, for the kids, that's where the biggest change. Okay, or whoever is not your spouse would inherit money. Now they have the 10-year rule in place. So basically, if somebody inherits an IRA or 401k for somebody else and they roll it over to their own IRA, again, they have to roll it over. So they just cash it out, they pay all the taxes at that point. And that's usually tax-wise not ideal because that might put you in a new tax bracket versus spreading it out over a period of time where it has, it doesn't raise your tax bracket as much, potentially. And so now the rule is now the 10-year rule, which means you're required, if you inherit and roll over an IRA into your own inherited IRA, you have 10 years to take the money out, assuming you're over the age of 18 when you inherited that money, okay, or inherited that IRA. Now, if you're under age 18, the 10-year rule won't start until you turn 18, okay? But if you're assuming you're over 18, you have 10 years to take the money out, and presumably what you're going to want to do is take probably 1/10 of the money out each year, so you can spread out the income tax hit, rather than, yes, you could delay taking, you could do the entire tax deferral for 10 years and then take it all out at year 10, but then again, typically you're paying a higher tax rate. But again, that's up to you. That's financial planning that you'll figure out when the time comes. But that's really the biggest difference now is if you are named as a beneficiary on an IRA 401k, you have 10 years, and that person dies, you inherit the IRA, you have 10 years to take it out. Now, if you do name the trust as a beneficiary, which there's certain circumstances like somebody with minor children, or we do our dynasty trust planning where we don't want the money going directly to the kids, then you will have to name the trust as the beneficiary, in which case then depending on the circumstances, the tax deferral, the RMD period, instead of being 10 years, might be as little as 5. Okay. Again, not a huge difference. And so definitely as an example, my kids are young, so I'm not going to name my kids as beneficiaries for a variety of reasons. And so I want the money to come to trust. If they can't do the tax deferral for 10 years, so be it at that point. But I'd rather not have my kids have direct control of the money as they currently are. If something happened to me and my wife tomorrow. So
Why can leaving a retirement account outright to children cause some unexpected tax problems?
Well, it's not so much a tax problem. I mean, well, it could be a tax problem, but the number one issue with naming your minor children, well, I guess there's two issues. If you name minor children as beneficiaries, that is subject to probate, okay? Because they have to decide who's in charge of the money, because your kids can't own the account because they're not 18 yet. So that's one issue with naming your kids as beneficiaries. That's why I haven't done it. And then the second is the other reason is I may not want my kids to have control of the money at as early as 18. I may want to have control of the money as later as 25. And the only way I can do that if they're under the age of 25 is, instead of naming the kids as beneficiaries, is naming the trust as the beneficiary. Now, the other, outright to your kids, I don't know if it's such a tax issue, is they may not, the reason why I don't want to give the money to the kids at 18, let's say, if something happened to my wife and I, is 'cause I don't want them making decisions like, well, I should just take all the money out of the IRA and pay all the tax. And it's just not that they can't do it. And maybe that, that's just maybe not the wisest thing to do at that point. Okay. So it's really not so much a tax. It's really the tax is going to be paid if they take the money out of the IRA. Whether or not they're in a good position to take the money out of the IRA, under control, in a thought out that makes financial and tax sense, versus just, the classic mistake we see, unfortunately, is people, they'll get a questionnaire from, after their parents die, they'll get something from the 401k company, say, do you want to take the money? And they'll say, yes, I want to take the money. Well, not understand is, yeah, you taking the money means you're going to pay a tax on all of it, versus the correct decision is you want to roll it over. Mm. So it's not so much a tax issue of leave it to them outright, is are they in a position to make the wisest decision? Mm-hmm. Or the other would be if there's a reason why they shouldn't have control of the money. Special needs, somebody's disabled. They have an issue where they shouldn't be in control of the money. Drugs or alcohol problem or something like that. Or it could be planning, like I said, I mentioned the Dynasty Trust, which I've talked about in other podcasts, where you want to offer your kids lifetime asset protection for that money. They'll have some protection under a 401k or IRA, but there's better protection under a Dynasty Trust. So in that case, instead of naming the kids as a beneficiary, you would have to name the trust if you want to have them the option to have the money protected under their Dynasty Trust.
What would be the difference between leaving a retirement account to a spouse versus children?
I mean, that's the fundamental question for, all my married couples is, are you going to take care of each other and require, legally obligate each other or morally obligate each other to take care? If you give 100% to your spouse, at that point, you're assuming if they don't use it all, and, even if they got remarried, that they would use that, that money would eventually go to the kids. But you would be morally, as a surviving spouse, you would be morally obligated to do that, not legally obligated. Mm. Obviously, You name the kids as a beneficiary, well, then they get it. Of course, your spouse doesn't get it, or whatever portion that you don't give to you give your kids, your spouse doesn't get it. And again, that's a question. Then, will they have enough to live on? That's all. I always, I tell, I obviously have a lot of clients who are concerned about, oh, what if my spouse remarries? I don't want all our money to go to the new spouse. I say, yes, we can prevent some of that. The question is, if you give, you say, I'm going to give half my money, half my share of the assets to my kids, will the survivor have enough to live on? Okay. And again, that's just a question we have to talk about and figure it out. And the other issue is, who can you trust? My kids are still minors, so, I'm not quite ready to trust them. So at this point, I trust my spouse more than them. So I'm going to have all the money go to my spouse and let her, if something happens to me, and vice versa, let the surviving spouse figure it out what to do, how and when the money should go to the kids at that point. Like everything else, it's always about a matter of trust.
A lot of options of how you can set this up. What are some mistakes that families make with retirement accounts in their estate plan?
I think the most common is naming, like I said, we just went over it, naming the kids as even as a beneficiary individually when they're young, either under 18, which would go to probate if something happened to you, or, young adults, before, say, age 25, where they maybe are not in a position to make the wisest decisions. So that's usually the biggest mistakes people make. And then the other is naming, if you do name individuals, like I mentioned, and they shouldn't have direct control of the money for a variety of reasons, then naming them individually means they would get the money directly. As long as they're over 18, they're entitled to the money. Versus, again, special needs, drug or alcohol problems, things like that. We need the money to come to an entity like a trust so that the money can be used to support them, but they wouldn't have any direct control of the money.
It's a great, you touched on this a little bit, and I want to know a little bit more about this. When does it make sense to use a trust as a beneficiary of a retirement account, and what are the pros and cons?
So again, the primary issue is if you name somebody individually and they're over 18, they get the money. Okay. And so if that's fine, and there's some circumstances, and this is a question I will pose to my clients, if you have adult children who are, mature and, you get the money, there may be some advantages to naming after your spouse the kids as named beneficiaries. It does make it slightly easier for them to roll over the account into their own IRA if they're named individually. It's not to say you can't do it if the trust is named. It's just the institution is harder to deal with because, well, unfortunately, a lot of people, these institutions just don't know what they're doing. And so you name individuals, it's very straightforward. You name a trust, it gets a little more complicated sometimes. If they would otherwise roll it over into their own IRA, it just might be easier to name your children as beneficiaries. Okay. Now, we already talked about why you should not name your kids as beneficiaries. But the other reason why you would consider not naming your children as beneficiaries is the trust is a better beneficiary. And this is general. This is true for all accounts. Generally, the trust is a better beneficiary than individuals, mostly because the trust doesn't die and it has all the backup plans. If you name an individual and that person passes away, the plan whatever happens to the money from there may or may not be what you want to happen. It'll be the company's default rules at that point versus your rules. And so if your rules are in your trust and the trust is the beneficiary, well, your rules govern. But if you name individuals, then their default plan the institution's default plan will not happen, which is typically if you name two siblings and one sibling passes away, the other sibling gets 100%. Okay. Now, in your trust, though, it probably says if any of your children predeceased and have their own kids, their share would go to their kids. Well, that may not necessarily happen under the default plan of the institution. The other issue that comes up, and I've had this happen to one client, again, this is not so much your kids versus your spouse, it's naming an individual, is on a life insurance policy, husband names the wife as the beneficiary, husband passes away first, wife dies an hour later. Under that circumstance, because the wife was named as an individual beneficiary, she became entitled to money, but obviously couldn't get it. Under those circumstances, because she was entitled to money and now her estate became entitled to money, the money went to probate. So even though the kids were named as contingent, it never made it past the wife. And so that's the issue with naming individuals is if they were to die after you, but before they had a chance to get the money, that money could get stuck in court. And somebody, families, instead of getting the money right away, would have to spend tens of thousands of dollars in legal fees and wait 1 to 2 years potentially to get it. So that's why, other than naming the spouse as the primary beneficiary, we generally do not recommend naming individuals as beneficiaries if we can avoid it, not naming individuals. Again, the 401k and IRA, again, that's the one where it's a little more up in the air because there is at least one other factor to consider, the ease. So again, that's a discussion I'll have with my clients to figure out what makes the most sense given the circumstances.
We talked about the Secure Act and how that made changes. How might retirement account rules change again in the future? And why is that important for families to stay current?
Obviously, the Secure Act was a big change because, and I forgot to discuss it. Before the Secure Act, the RMD age for the children was based on the oldest age of the oldest beneficiary. So if they reached the age of 70.5, everybody had to start taking money out of the IRAs. And so, and that law might change. I haven't seen any impetus to change the law at this point. Obviously, the government wants their money sooner. They don't want the generational wealth issue coming up. So I guess, if they ever went back to the old way, the biggest change is there's some potential planning you could be doing as far as, and again, it wouldn't be so much the planning you're doing, is that the future financial planning will be, keep the money going, keep the money in, only take out the RMDs, keep as much money as you can in the IRAs or 401ks, and hope that you can pass it on to the next generation. But again, I don't know that we're ever going to go back to that system.
What's one practical step that families can take this year to make sure that their retirement accounts are protected in their plan?
Number one, check who the beneficiaries are. You'd be surprised how many people have no idea. Usually, the good news is that you were forced, when you created the 401k, you were forced to put a beneficiary, because a lot of accounts you're not. Now, obviously, a lot of people had 401ks prior to getting married and, never got around to updating to include their spouse. That obviously is problematic. So it's really, who is the beneficiary? That's, inventorying your accounts. That's something you should be doing all the time. Where's all the money at? But more, you want to make sure, where does the money go? And is that the right person? And, or should it be the trust, if you assume you had one? That's the number one thing we're looking at doing, that, you should be doing. Now, obviously, once you do it, it's done. But, again, people forget. But you do want to, double check to make sure, especially, and I have clients, who have elderly parents. I say, this is a good time. You need to check everything. Because if things aren't set up right, there's beneficiaries that aren't alive and things like that, or it's one of the wrong persons, you need to get those things updated while that person can update those things.
A lot of great tips in this episode. Thank you so much, Brian. And thank you for tuning into today's episode of Estate Planning Beyond the Binder. Retirement accounts are often a family's largest asset, and with the right planning, you can protect them from unnecessary taxes and make sure they're supporting your loved ones the way that you intended. To learn more or to schedule a consultation, visit ocwillsandtrustattorneys.com or call Brian and his team today. And don't forget to like, subscribe, and leave a review if you found today's episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.